afternoon and welcome to Contract Drafting in 90 Minutes. This is a panel for people who really want to know what's next in transactional education, but who would first like a little transactional education themselves. We propose to give you a primer in how to draft a contract in 90 minutes, maybe even a little less. And so if you're interested in teaching contract drafting or other transactional skills courses, but your own practice background is in another area, then this is the panel for you. Charles Fox and I plan to give you a great springboard for making the most of the next day and a half of this wonderful conference here at Emory. Charles Fox is a transactional lawyer with over 22 years of experience in drafting and negotiating complex commercial agreements. He's the author of Working with Contracts, What Law School Doesn't Teach You. And of course, the purpose of this conference and others like it is to make sure that law school does teach you that stuff. But in the meantime, Charles's book is a real handy way to learn it. He's an adjunct professor of law at Pace Law School and the founder of Fox Professional Development, which provides training programs in contract drafting and transactional skills to lawyers in practice, both junior and experienced lawyers at law firms all over the country. My name is Jane Scott, and I'm an associate professor of legal writing at St. John's University School of Law in Queens, New York. I practiced real estate and development law for 17 years in New York before going into teaching. And it was my dream in those years of practice, during which I spent all my time drafting and negotiating contracts, to someday teach a course on the topic. I had a file folder of materials that I saved over the years, and I will never forget the excitement of getting a flyer in the mail announcing the publication of Tina Stark's first book, Drafting Contract Boilerplate. I just thought that was the most exciting book to come down the pike in a long time. And I was finally able to realize this dream of teaching a course on drafting contracts last year at St. John's, where I now teach a one-semester course for upper-level students in contract drafting. The book that I use in that course is Tina Stark's book, Drafting Contracts, her textbook for law school courses, and the materials I'll be presenting to you today are drawn from her work. I'm going to start by covering the key contract concepts, and Charles Fox will then discuss contract drafting techniques and contract organization. Let me just ask you, how many of you have ever signed a contract? And I know many of you have probably signed a contract without reading it, but that's so embarrassing to admit when you're a lawyer that I'm going to assume that you've read some of the contracts that you've signed. How many of you have ever reviewed a contract for someone else? Client, or one of those non-paying clients that we also call family members and friends, who know there's something at stake if they're signing a contract and want you to look at it first and advise them. How many of you have ever litigated a contract? Been involved in the resolution of a dispute arising out of a contract? It's pretty hard to be a lawyer and not have something to do with contracts, even if you're not a transactional lawyer. The difference is that if you're a transactional lawyer, you don't encounter a contract in its final written form. You have to create it. Instead, you encounter a contract, it comes to life in your practice as usually a term sheet, a set of business terms that the parties to the deal have agreed to already, and that you need to translate into one of those full-blown contracts that someone is going to read and review before signing. So our initial task as transactional lawyers is to translate these business terms into legal concepts, into contract concepts, so that we can organize and draft the contract to make it effective and clear. And what I'm going to go over with you is what those concepts are and how to recognize them in business terms. The key contract concepts are representations, warranties, covenants, rights, conditions, discretionary authority, and declarations. In your handout, actually, Charles Fox's presentation appears first. So if you scroll, or rather, using that other technique, turn the pages past the blue intervening sheet, you'll find this presentation that I'm giving right now. And we'll start at the top and talk about representation. Let's suppose that I have a used car that I want to sell and Charles is interested in buying it. Assuming that he wants to drive the car rather than just look at it, the thing he's probably going to be most interested in is what condition it's in. So he's likely to ask me questions like, how many miles are on the car? Let's say 75,000. What kind of condition is it in? It's good condition. I've never had any problem with it. Has it ever been in any accidents? Well, my daughter tore the front fender off, backing it out of the garage, but other than that, no. Has it been well maintained? Yes. I've always kept it serviced in accordance with the owner's manual. These are all statements of fact, as of a moment in time now, intended to induce reliance by Charles. They are representations. And when drafted, they look something like this. The seller represents that the car is in good condition. Now, even if you're not a transactional lawyer, you're probably noticing that something's missing from this statement. There's another verb that we're used to seeing in conjunction with represents. What is it? Warrants. Okay. We would typically expect to see seller represents and warrants that the car is in good condition. And this is not an example of using two words to draft something that can be said with one, which is a feature of many traditionally or poorly drafted contracts. Contract is likely to say seller sells and conveys, when only sell would do, or suffer and permit, where only one would be sufficient. Representation and warranty mean two different things. A warranty is a promise that a statement of fact is true. In the real world, what that means is that the maker of the statement will pay damages to the recipient if the statement isn't true and the recipient suffers damages. Why should a person receive both a representation and a warranty with respect to a particular statement of fact? Because they differ as to the requirements for a cause of action and the remedies available if the statement is not true. Remedies for misrepresentation differ depending on whether the misrepresentation was honest or negligent on the one hand, or fraudulent on the other. For honest or negligent misrepresentation, the remedies are avoidance and restitutionary recovery. You can get out of the contract and get back what you paid. Suppose the car needs new brake pads, and I didn't know that, but I reasonably should have in the exercise of due diligence, if I really had been taking that car in for servicing, as I claim to have done. So it's a material misrepresentation, it's a negligent misrepresentation. Mr. Fox can avoid the contract and obtain restitution. Fraudulent misrepresentation provides a choice for the injured party between avoidance and restitutionary recovery, and on the other hand, damages. The damages may be out-of-pocket damages rather than benefit of the bargain damages, depending on the jurisdiction in which the action is brought. Plaintiff also has to show scienter, that I knew the brake pads needed to be replaced. A cause of action for breach of warranty, on the other hand, relieves the plaintiff of the obligation to show reliance or to show scienter, and to show scienter on the representer's part. And the damages available are benefit of the bargain damages regardless of the jurisdiction. So why receive both of these in your contract? Because it gives you a choice of remedies and a choice of causes of action, which may be important based on the facts available. Suppose that Charles and I reach agreement over the condition of this car. He hasn't figured out yet that it needs new brake pads, and he agrees to buy it. The term sheet that I get, that you would get from the client, might simply say, purchase price, $5,000. That's what he's agreed to pay me for the car. But what does that translate into as a contract concept? It's a covenant. A covenant is a promise to perform. It can be a promise to do something or to not do something. It creates a duty or an obligation to perform, and obviously most of what contracts consist of and contain are covenants. So seller shall sell the car to buyer, buyer shall pay seller $5,000 for the car. That's what we translate that one little business term, purchase price $5,000, into. And the contract may well contain other covenants not having to do with the price of the car, such as seller shall not drive the car more than 500 miles before the closing date. There may be any number of things that seller has to promise buyer she will do before the contract is signed. And those take the form of covenants. A right is merely the flip side of a covenant. If I'm obligated to repair the car, then Charles has the right to my performance of that promise to repair the car. I promise to maintain the car in good condition until the closing. That's a covenant. Charles has a right to my performance of that obligation. Each covenant creates a corresponding right, but the right need not be separately expressed in the contract. And the better practice is to draft an obligation as a covenant rather than as a right to receive the obligation. Suppose that Charles finds out about the brake pads and insists that I fix them before the sale takes place. The term sheet might say, seller to replace brake pads before closing. That's a covenant on my part to fix the brake pads. But suppose Charles, being a savvy transactional lawyer, wants something more than that. He doesn't just want my promise. He wants to make it a condition of his obligation to buy that I have actually fixed the brake pads. And that brings us to our next contract concept. A condition to an obligation is a state of facts that must exist before a party has an obligation to perform. And the contract might say, for example, to make that happen, buyer's obligated to purchase the car only if the following condition has been satisfied or, less likely, waived by him by the closing date. Seller must have replaced the brake pads. And that way, he's not obligated to buy the car if I haven't done so, setting aside whatever damages he might be entitled to for the breach of the covenant to do so. Conditions can be ongoing conditions, not just walk away from the deal conditions. Here's an example. Suppose Charles wants to look at the car's warranty. I don't have it handy at the time we sign the contract. So I agree. I covenant that I'll give him a copy of the warranty. But there's a condition to that covenant on my part, and that is that he has to notify me, perhaps in writing, that he wishes to see it. So we've got conditions of various kinds to these covenants. Taking a look at the interplay between these concepts and how far we've gotten so far, and looking at it in the context of the mileage of the car, I've represented and warranted that it's only been driven 75,000 miles. And I've also covenanted that I won't drive it more than an additional 500 miles before the closing date. And it's a condition to his obligation to buy it that I've complied with all the covenants in the contract, including not driving the car more than 500 miles, fixing the brake pads, and whatever else I might have agreed to. Now, the parties may have agreed, we would have to agree as part of this contract for the sale of a used car on a closing date. Let's say we picked June 14, 2010. But Charles is such a busy guy with all these seminars he teaches and all these conferences he attends and presentations that he makes that he needs the right to postpone the closing date if necessary by a little bit. So the term sheet, that business term sheet that you get from your client, might say something like, closing to take place June 14, but Fox may extend the date on written notice to Scott. What's that? That's discretionary authority. It's not a right on his part to extend, because a right is the flip side of a covenant. It's authority on his part to do or not do something as he chooses. He's not covenanting to extend the closing date, but he has the authority to do so if he chooses. Discretionary authority gives a party a choice, or gives a party permission to act, sometimes when it's been otherwise denied. So buyer may extend the closing date by up to 1 week. That's his discretionary authority, and the key verb is may, by sending written notice to seller. An example of the sort of permission to act where it's otherwise being denied would be, seller shall not paint the car before the closing. That's a covenant not to paint it, except that seller may repaint the car its existing color and shade. That's discretionary authority. And we can have conditions to discretionary authority the same way as we can have conditions to covenants, simply a state of facts that must exist before the discretionary authority can be exercised. Charles might want to have this car inspected by a mechanic before he buys it. But he's not sure he's going to do that. It's discretionary authority. It's not a covenant on his part. It's subject to a condition, though, because if he wants to have it inspected, he has to notify me of the date of the inspection at least 5 business days in advance, so that I can make arrangements to get it here. So we've got a condition, but it's a condition here to discretionary authority rather than to a covenant. And finally, we have declarations. You can take any sentence in a contract and pigeonhole it within one of these 7 contract concepts. And what you're left over with after you've identified the covenants, the rights, the representations, the warranties, the discretionary authority, and the conditions are declarations, which are usually statements of policy that the 2 parties to the contract have agreed to. They don't entitle either party to any right or remedy, but they express the policies that the parties have agreed will govern their contract. An example are all those types of provisions that appear in that wonderful boilerplate language that Tina Starker wrote her first book about. Provisions relating to choice of law, choice of forum, dispute resolution. Any dispute arising under this agreement is to be resolved by arbitration. That's a declaration. The laws of Georgia govern all matters relating to this agreement, including torts. That's a declaration. Declarations are also how we categorize definitions, and as you all know, contracts are filled with definitions. They're a housekeeping tool, a tool for clarity and consistency, and a definition like purchase price means $10,000 is a declaration. It's kicked into effect by the covenant, buyer shall pay seller the purchase price at the closing. Now we know purchase price means $10,000. But the bare statement, purchase price means $10,000, is a declaration. So there you have it. Our 7 contract concepts. Representations and warranties, covenants, rights, conditions, discretionary authority, and declaration. And just as a reminder, you can have a condition to an obligation or covenant, a condition to discretionary authority, or a condition to a declaration. Now what I'd like to do is give you a little test. If you turn to the last page of this handout, well, actually, it's not the last page. It's the last page before the second blue piece of paper. And you'll see something called contract concepts on a page. This is a summary of the 7 contract concepts as we've just discussed them. I'm going to show you some business terms on the screen. and see if you can tell me what contract concepts you would put them into. And let's start with this one. Mr. Alvarez will be reimbursed by the firm for all expenses incurred in performing the job. Which of the 7 contract concepts would you categorize this as? It could be more than that.
Covenant.
It's a covenant, right? And who's covenanting?
The firm.
The firm. It's written almost as if it were a right on Mr. Alvarez's part. We'd be better off writing it as a covenant on the firm's part. So we'd say the firm shall reimburse Mr. Alvarez for all expenses incurred in performing the job. Right?
You're making a distinction between in the drafting aspect rather than the legal aspect when you say a right or a covenant. As far as I'm concerned, if I covenant something to you, you've got a right.
Well, that's right.
Okay, I just wanted to get that clear.
Right, but and so this from the term sheet amounts to a covenant with
Yes.
its corresponding right unexpressed, and we draft it as a covenant for greater clarity, especially if we were representing Mr. Alvarez.
Right.
How about this one? The firm can withdraw the offer of employment if Mr. Alvarez does not receive his MBA degree by June 15th, 2010. Coming right up. Condition to what? Discretionary authority. The firm has discretionary authority to withdraw the offer of employment if he doesn't get, to withdraw the offer of employment. They don't have to withdraw the offer, but they have discretionary authority to do so. The condition to that authority is his not getting his MBA degree on the 15th. This is a rather easy one.
Declaration.
It would be translated into a representation and warranty, and we draft it. Seller represents and warrants to buyer that the property is zoned for commercial use and has sewer and water service. Why is it not a declaration? Because if it's not true, a party should have a remedy, the buyer. The buyer's relying on the statement.
But it doesn't say which party.
No, but that's the thing about a term sheet.
Right.
When you get a term sheet from your client, that's the kind of abbreviated language it's written.
Right. I would have put it in the statement of purpose. But that, as I read it, that's the way that I would have classified it.
In the statement of purpose?
I didn't see it, I didn't read based on what you had that it would be a rep or warranty.
You mean?
Because it doesn't seem to me that it's a promise that this is the case.
Right, right. It would all depend on the context, you know, where it appeared in the term sheet. If it were a sale of commercial property, it might be more clear that it was rep and warranty. And sometimes clients will very clearly say, sell it to rep and warrant the following. You had a question, sir.
Peter, they had a question.
Well, I guess the only thing I'm thinking about is the question of recitals, which are very important, but also very dangerous because of the fact that they can turn into representation. It seems to me that's clearly a warranty and a representation, but
Right.
there are cases saying you got to say warrant, but I wouldn't let anybody sign that unless they recognize that it was a representation. It would liable to get in a lot of trouble for that.
Right. We translate this into a rep and warranty, and we draft it as a rep and warranty. And if it were recited in the recital section, which Charles is going to talk about, that might be superfluous and certainly wouldn't be sufficient to create the right.
Oh, sorry, go ahead. Sorry.
I was just going to say, I think that's exactly the point that you're making, is that how you write it.
Right.
If it is a representation, then you write it as if it's a representation, and you have to recognize from the terms. I think that's exactly what you're saying.
You might also want to cast as a condition to the, unless the property is sold for commercial use, sewer and water service, then the buyer has no obligation.
Right, and typically there'll be a condition to closing, which is all the seller's representations and warranties must be true.
Yeah.
Which picks it up. Yes.
I was just going to ask, going back to your list before, Jane,
The arbitration provision, isn't that really a pair of covenants?
Yes, it is. I mean, and to kick it into effect in any way, you'd have to have multiple covenants on each party's part as to how they're going to select the arbitrators, how they're going to pay for the arbitration.
Yeah, unless the court ends up having to, you'll have a question of whether it's enforceable without those details. But what's happening is each party is agreeing to arbitrate any dispute that isn't settled in formal.
That's correct. So as a drafting matter, you'd have it as a declaration, and you'd also need to create specific covenants to implement it, make it a reality. But the big...
it's gonna hit the road if there's a dispute that isn't settled informally and one of the parties wants to arbitrate and the other one doesn't.
Right.
And then so the person is going to say, this is an arbitration agreement, it's enforceable under the FAA or under a state arbitration act. So one of the parties may be compelled to arbitrate.
If you get a term sheet from your client which purports to set forth the agreed upon terms by both parties, and it says all disputes to be resolved by arbitration, what that's telling you is that as a policy matter, the parties have decided to resolve disputes by arbitration, and that you as the drafter need to include that declaration as well as the covenants that will make it enforceable and that will address the practicalities of arbitration. Let's just do a few more of these, and then I'm going to turn you over to Professor Fox. The publisher can accept or reject the final manuscript or accept it with changes. Discretionary authority. If the company terminates the executive without cause, the executive will be paid $100,000.
It's a covenant and a condition.
It's a covenant and a condition. A covenant on the company's part to pay the executive $100,000, subject to the condition that he's been terminated without cause. And any disputes will be litigated in Texas courts. This goes back to our prior discussion. Well, I think you all deserve an A. And you're ready for Professor Fox's presentation. And thank you very much.
Thank you.
I'm trying. There you go, sir.
Okay, thank you. You didn't include all of them.
What?
Yeah. Okay. So, hello everybody. I'd like to just follow up on one of the topics Jane covered before I get into my scheduled presentation, talking about reps and warranties. And actually, when I teach this subject, and I'm usually teaching not to law students, but to first-year lawyers, but guess what? They don't know anything more about contract drafting than law students do, so it's the same thing, except they're being billed out at $200 or $300 an hour for that lack of knowledge. But when I talk about reps and warranties, I usually start with a personal anecdote, which has to do with the sale of a used car. But this actually happened to me. When I got my first job as a lawyer, I was very excited to be making a paycheck, and my wife and I decided to sell our car, which had been breaking down more and more frequently. So we're going to sell our used car and buy a new car. So we put an ad in the Penny Saver selling our Buick Skyhawk, and we asked for $800, and we hoped that we would get $400 for the car, because it really was not such a great car. So the first guy who answered the ad came over. He, kind of walked around the car. He got in, sat in the driver's seat, and started it. And we were holding our breath because it didn't always start, but this time it did start. And he gets out of the car, he pulls out his checkbook, and he says, "Who do I make the check out to?" And so my wife and I gave each other these glances like that. And we took his check. And later on that evening, my wife was very upset. She felt that she had done something wrong. She said, we did something wrong. We should have told him about the problems that the car had. And I said, we didn't do anything wrong. And of course, I was answering that question as a lawyer, not as a human being, because that's how I'd been trained in law school. I said, we didn't do anything wrong. The rule of caveat emptor says that it is up to the buyer to ask questions and to get information. So in this case, in this transaction, the buyer should have done due diligence, taking it to a mechanic. And he also should have asked us questions. He should have asked us the following question: how does the car run? And at that point, we would have had three options. We could have said, the car runs great. What do we call that?
Fraud.
You'll be surprised how many first-year lawyers would answer that question by saying, lying. I said, yes, it's lying, but we lawyers call it fraud. That would have been fraud. Our second option would have been to say, we choose not to answer your question, which we would have every legal right to do, but I think this guy, dim bulb such as he was, would have gotten the message at that point and would have walked away. Or third, we could have told him the truth, which is what we would have done if he'd asked us the question. It was his job to ask us the question. That is what reps and warranties are. It's asking the other person to the contract to stand behind the facts that you're relying on in deciding to enter into the transaction. All right? And I have found that to be sort of a very effective way of getting people to sort of understand what reps and warranties are, because reps and warranties, those terms sound very mysterious. They're not mysterious. Just like the term due diligence. And by the way, if anybody out there knows where the word due diligence came from, I'd really like to know, because I've been trying to figure it out. But due diligence, all we're talking about is doing a reasonable investigation of the facts. So these are just examples of how we lawyers have cloaked things in terminology that's mysterious, but is really very much just common sense. Okay. So,
I have a question for you.
Certainly.
So, how did your wife respond to that?
How did my wife- It was the one, I think it might have been the only time in our marriage that she was glad that I had responded like a lawyer, because she said, "Oh, thank God, we're okay." So yeah, she was relieved.
And did the check clear?
The check cleared. Check cleared.
Well, I wasn't going to interject, but now that people are interjecting, I'll say the real answer to the question from a negotiation standpoint is you did make a mistake, which is when anybody from a buyer gets their checkbook out that fast with no questions, you left money on the table. That's what you did.
Well,
$1,000 was the sale.
that I might have felt bad about that. So the remainder of my comments really are going to be focusing on one overall theme, which is how drafting contracts is different than other kinds of writing. That's the general theme. What I'd like to start by doing is talking about how contract drafting specifically is different than most other kinds of writing that your students do all the time. What your students know how to do is to do expository writing, and in their legal writing class, for the most part, they're learning to write briefs and memos. And, whoops, sorry, wrong way. Expository writing can be illustrated in the following way. Now, I have two guys here, and it's interesting because my usual audience, they know who the guy on the right is. They're not so sure about who the guy on the left is. Maybe in this audience it's turned around. But here we have Alan Greenspan is writing a letter to Bono. I once called him Bono and my kids just, they were so dismayed when I called him Bono. He's Bono. So Alan Greenspan's writing a letter to Bono, and he's saying to Bono, Attached is an article that I'm about to publish on the effect of credit default swaps on long-term interest rates, which I thought you might be interested in reading. And by the way, I saw you guys in Toronto and you were awesome. Okay, so he's writing that letter, and what that is an example of expository writing, which is when we chart it out, effectively what you're doing is you're taking something in the brain of the writer and conveying it into the brain of the reader. They're either trying to convey information, trying to persuade, trying to amuse, but you're essentially conveying something from one brain to another. Now let's say Greenspan and Bono are entering into a joint venture. They need to negotiate a contract. The paradigm of contract drafting is different, because in contract drafting, that arrow changes to a two-sided arrow. And this is the so-called meeting of the minds, which everybody knows about in contract class. But the meeting of the minds, I believe that the getting to a true meeting of the minds is one of the lawyer's most important functions in getting a transaction done. Why? Because our clients, more often than not, think they have a meeting of the minds when they just have the beginning of a true agreement. And it's our job as lawyers to force them to think about and address the more difficult issues. It's human nature to want to try to not think about the hard stuff. We have to force our clients to think about the hard stuff. And I'm going to skip a couple of slides here to look at this slide, which is a pretty common example of the way clients are. Your client calls you up and says, "We've just agreed to acquire this piece of used equipment for $15 million. Draft up a purchase agreement, but don't spend a lot of time on it, because we want to close tomorrow." Well, I use this example for a couple of purposes. I use it as a way of starting to show my students that our job as lawyers is often to push the client in a direction that they don't really want to go. Not necessarily just to blindly do what they tell us to do, but also to illustrate how we as lawyers add value, not just by dealing with legal issues, but by forcing the client to think about business issues. So, I'm just going to ask you folks, the same way I'd ask my students, all right, what does the client need to be thinking about here? They're telling you they just want a one-page purchase agreement. And if you do that, you're not serving your client properly, because there's a whole bunch of issues they haven't thought about, which they should be thinking about, and there should be an agreement on. What? Now, none of you, I think, are in the business of selling used magnetometric gloop extruders, but you all know what some of the issues are. Yes, sir?
How is it going to get paid?
How is the payment going to occur? Is it going to be cash? Is it going to be note? Is it going to be a check? Is it going to be an exchange of services? What? Yes?
What does this thing do, and how do we know whether it's going to work?
How do we know whether it's going to work?
How do we know whether it is working the way the client wants it?
Right. Do you want a right of inspection? Do you want some representation about
how much gloop it does per hour?
How much gloop it does per hour, exactly. What else?
What happens if it stops working 2 days after you get it?
Okay, great. Is there going to be any kind of a warranty on it, or any promise that it will perform in a certain way? What else?
Does he own it? Does he own it, and does it have any liens?
Does he own it? It's always a good thing for a seller to own the thing that it sells. In fact, if you drafted the purchase agreement without getting a rep as to title, and it turns out after you buy it that there's a cloud on the title, do you think you've committed malpractice? Maybe, probably. Yeah. What else? Yeah.
Will the seller deliver it to you, or will you
deliver it? Right. Big question. How is it delivered? Are they going to hook it up? Are they going to put the gloop connection in, or whatever it is? All those questions. Well, we could go on and on, but the point here is that as lawyers, we play a hugely important role in getting this first step of doing a contract, which is making sure there is a true meeting of the minds, making sure that all of the necessary issues have been thought about and addressed. It's not easy because clients usually would just assume not have to be on the phone with their lawyers. But we make them. Okay, then once we have a meeting of the minds, then the next step is to draft the contract in a way, first, that precisely reflects the meeting of the minds. In an ideal world, it's so precise, the words so precisely reflect that meeting of the minds that the parties can never disagree about what the contract said. And the contract has to be so precise that every future reader of the contract interprets it to mean exactly the same thing as the parties intended. And those future readers could be the clients themselves, could be, okay, this here's that. Okay. There we go. Okay. Readers could be the client themselves, could be some litigator who's been asked 2 years down the road to help the client fight the other party over the contract, and ultimately could be a judge. And one of the key aspects of contract drafting and contract negotiation is not only are you trying to create a roadmap, a clear and precise roadmap for a business relationship, but we're also trying to do it in a way that precludes arguments. We are, I believe that deal lawyers and litigators are kind of natural enemies in the jungle, because our job is to keep there from being work for the litigators. And the litigator's job is, when they're handed a contract, is to read through it and find every ambiguity, every soft spot, every bit of infelicitous wording in order to try to achieve a benefit for their clients. So the ideally written, precisely written contract is one that doesn't give that tough litigator any wiggle room to argue that the contract really says something other than it was intended to say. And the contract formation process performs all of these very valuable functions. It forces people to realize what they have to give up in order to get what they want. Now, if we follow the traditional Japanese method of doing transactions between, say, big companies, they sign, and this is changing, but in the old days, they'd sign a 5-page agreement and say, well, we'll worry about all those other issues when they come up. And that worked within that culture because that culture is a very collegial culture. American culture ain't collegial. No one wants to give up something for nothing. So by thinking of all the possible issues up front and addressing them, you're facilitating a much easier relationship, because invariably the contract doesn't address some important issue and it comes up afterwards. One party's going to go to the other and say, hey, how about doing this for me? And the other party's going to say, no, well, I demand a quid pro quo. It's much easier to get those issues resolved when everybody's in the negotiating mode and in the negotiating spirit. When I started practice back in 1983, I actually had a wonderful experience. I went to work for a firm, and the firm was working on smallish deals, and I was just right out of the box told to start drafting agreements. So I was doing a lot of drafting from the very start, which is unfortunately very rare these days, or more rare. And when my friends who weren't lawyers would ask me, well, what do you do all day? I say, I write credit agreements. My client is lending some company $10 million. Back then, that was a lot of money. And I write an agreement that governs that. And they would say to me, well, what's the law? What's the law? And I would say, that's the great thing. There is no law. I'm just writing stuff. And the words that I write, because in those days I used to use one of these, the words I write become private law between the parties which govern these big, well-known companies. I mean, I would thought I was pretty hot stuff. Now, of course, we know that's not true. There is law, but in fact, for many transactions, the law is quite secondary to the business issues. What I tell my students about the law, well, first of all, I tell them, you know all that stuff you learned in contracts class? Sorry, but it's not going to come up all that often. I worked on deals for 22 years, and not once did I have to scratch my head and say, is there a consideration here? You know, I mean, it's important to know that stuff, but the basic contract law things are not what governs, for the most part, are not what's going to govern your activity as you're drafting a contract. Here are the things, the law, that is most important to you when you're drafting or working on a contract. And it's these two rules of contract interpretation, which are actually both rules of evidence as opposed to contract law rules per se. The parole evidence rule, no?
No, they're both substantive rules of contract law.
Okay.
Every state and union.
All right, fair enough. So they are contract law, that's good. I'm glad to know that. But these rules taken together are what makes it so important for lawyers to get the words right in the contract. Precision. You know, if you're a legal writing instructor, you're always trying to, or you know, anytime you're dealing with writing, you always want writing to be precise. In contract drafting, that rule is paramount, and if you don't follow that rule, that's where you get into problems, because based on these two rules and others, most often, if you're in a dispute about what the contract does, you're going to be prevented from trying to convince the court or the trier of fact that the contract actually means something other than what it says. So, for example, if you're drafting a brief, let's say you're drafting a brief, and on the last page of the brief, it's a 50-page brief, and the last sentence of the brief you write, for all the reasons set forth above, this court should not grant plaintiff the relief that plaintiff is seeking. And somehow, the word not is dropped from that sentence the night before it gets submitted to the court. So you have a brief where the last sentence of the brief, you're asking the judge to do the opposite of what you've spent the last 49 pages trying to convince them to do. Is a reasonable judge going to decide the case against your client based on that sentence? Of course not. Of course not. Now, it's not a good thing, and it would be very embarrassing, but it's not going to affect the outcome of the case. Contrast that with a contract term where the word not is omitted accidentally. What happens then if the parties end up having a dispute about that? The party who is saying that it was written the way it was supposed to be written that way is going to win. We live and die by the words on the page.
Well,
and
there is a doctrine of reformation.
Yes, but, okay, and my response to that is,
Doesn't ever happen.
you don't, believe me, you don't want to be explaining to your client why you're in court, you know, trying to make those kinds of arguments.
Right. Yeah, I think that's the point. There's an exception for all evidence for mistakes, but who wants to litigate that question?
You know, law
That's the
students
thing.
have learned to make arguments.
Yeah.
And I always, you know, tell the people I teach and told the people who work for me, I don't want arguments. You know,
Agreed.
you tell the client when they're in litigation because the contract is not clear, oh, don't worry, we've got a good argument. That's not going to get you very far. You always, always, always do it the way it's not going to lead to an argument. So, yes, there are always exceptions to rules, but, you know, you don't want to ever get there. It's like the implied covenant of good faith. People ask me about the implied covenant of good faith. My response to that is, if, as a deal lawyer, you are relying on the implied covenant of good faith. You are out of your mind, right? The implied covenant of good faith is something litigators use when they got nothing better to argue. You don't want to rely on that when you're putting a deal together. Yes.
It also depends on your perspective. If your client is, if you're writing the language the way you want it in the contract from your client's point of view, but your client is out there making contrary representations to the other party at the same time, your client can have problems as a result of that. In other words, sometimes I listen to lawyers who draft contracts talk about how frustrated they are because their merger clauses don't work completely.
Right.
And the plain meaning doesn't always mean they get what they want, because the client is doing things that undermine what the document says.
Yes, absolutely, and I'll make 2 comments on that. Number one is the old saying that practicing law would be great if it weren't for clients. And number 2, when I was a first-year associate at K. Scholler, the head of the banking department was this really classic, older New York garment center lawyer. And one day, we were walking down the hall, and he put his arm around me, and he goes, Charlie, he says, you're going to be working on deals. And he says, I'm going to give you the best single piece of advice I could ever give you. He says, you're going to be working on deals, and you're going to be negotiating with some lawyer on the other side, and you're going to start thinking that other lawyer is your enemy. He says, don't ever think that. He says, that lawyer is not your enemy. Your client is the enemy. Never forget it. Your client is the enemy. And I thought he was nuts. But over time, I realized that he wasn't nuts. And so that's just one example of that. Yes, I mean, if your client is going off and doing things like that, it's almost impossible to protect them from themselves. Yeah.
I spent 11 years advising Corbin's volume on the 411s.
I'm sorry, advising?
I said I've spent 11 years advising Corbin's volume on the 411s, who was going to the printer next month. And, I've got a whole book about the problems with these things. And I believe strongly in allowing in extrinsic evidence, etc. As a draftsman, I want to be as Wilsonian as I can. I want to get everything on paper. I don't ever want to end up with those things.
Absolutely.
As a judge, I might feel differently, but as a draftsman, I absolutely agree with everything you're saying there. And for example, one of the things that when we're doing turnout agreements, is there a duty to work?
Right.
Well, Christ, if you don't put that in the papers
right.
about a duty to work, maybe you win, but
who wants to have to buy that way?
Yeah.
I mean, that's an implied covenant of good faith thing.
Sure.
You're not going to want to rely on that.
Right.
Yeah.
Exactly. Yeah.
Yeah.
Yeah, I was the general counsel of a public company, so I want to speak to clients. I'm curious, Charlie, if you are as precise in your drafting, and both sides are as precise as you make it out to be, the client looks at it and says, I'm not engaged in contrary representations for purposes of parole evidence rule. But I've got a $100 million acquisition here that ought to be resolved in less than a 500-page agreement.
Yeah.
Because the lawyers are so precise that every representation was negotiated as though it were the rest of the tops treaty. So what's the response to that?
Well, the response to that is
the client's still the enemy.
No. In that case, I'm totally with the client. And my response to that is, to me, that is the dividing line between the good lawyer and the not so good lawyer. Good lawyer knows what's important and knows when to fight the battles. And as we'll see later, I've got some slides later on which talk about this tension between trying to achieve this holy grail of precision and knowing when enough is enough. And the image I use to illustrate the enough is enough is I call it the line of dust, right? Where you take a broom and a dustpan and you do this and then you do that, and no matter how hard you try, there's always that little line of dust, and a good lawyer needs to know when just to take the broom and go like that. So a good lawyer working together with a good client will be able to figure out what the proper level of precision and care is. Because in fact, if you were to try to create something that was 100% precise, where every term was defined to the nth degree, you know, it would end up being this thick, and nobody's interest would be served. So you have to find the balance. I definitely agree with that. Mark?
Maybe an observation for teaching purposes, but it strikes me that it comes out here too. I spend some of my time teaching first-year MBAs commercial law, so we just gloss across and do a basic contract. And they're frustrated and angry at me as a lawyer because so much of it is not fair. They think that it's going to be fair, right, at the end of the day. And I remember back in law school when we studied the UCC that so many of the rules, we talked about the balance between certainty and fairness. And I've used that a lot in contract, teaching about contracts and contract drafting. And I think it's a valuable vehicle for teaching basic contract drafting. Parole evidence rule is a great example, right? The rule itself is about certainty. It may have unfair consequences if your client's been running out there making representations that are contrary to what went into the agreement.
Yeah.
So you try with this merger and integration clause to nail down only to what's in the agreement. And you have something that's certain that won't be litigated, and the parties won't spend a bunch of money in litigation and discovery on because the document says what it says. But that certainty comes at a compromise of fairness.
Right.
And I think so many of the contract rules sort of fall somewhere along a compromise in that spectrum.
That's a really good point. So we got two balancing acts here: precision versus just getting things done, and practical necessity, and the balance between, you know, between fairness and, you know, and certainty. Let me keep going. What I'd like to talk about now are the four most common ways that contract drafting gets screwed up: ambiguity, use of unnecessary words, vagueness, and inconsistency. Let's start with ambiguity. Ambiguity exists when you have a contract provision that can be read to mean two completely different things by two reasonable readers. And obviously that is not a good thing. The way I like to visualize this is think about those optical illusions you've seen where there's a drawing, and if you look at it one way it looks like an old woman, and if you look at it, you turn your head and you look at it this way, it looks like a young woman. Same thing. And what I have up here on this slide is 3 examples of provisions that are flawed by ambiguity. What's the problem with the first sentence in terms of an ambiguity in it?
Modification.
Are you talking about quarterly delivery of sales reports and litigation reports, or are you talking about quarterly sales reports and litigation?
Right. The word quarterly is a modifier. It clearly modifies the phrase sales reports, but does it also modify litigation reports? Maybe yes, maybe no. Yeah.
Requested by licensor. Does the licensor have to request the quarterly sales reports in order to get them?
Same problem. At the end of what we have here is a series. It's only a 2-item series: sales reports and litigation reports. And there are modifiers on either end, and the modifier at the end, requested by licensor, clearly modifies litigation reports, but may also modify sales reports. We don't know. So this provision can actually be read to mean a whole bunch of different things. Now, can I stick with you? Okay, we're going to rewrite it. So let's just say that here's the deal. The deal is, what this is supposed to say is that licensee has to deliver 2 things. 1, they have to deliver sales reports every quarter. And 2, when requested by the licensor, they have to deliver litigation reports. That's the deal. Now, one of the problems is this sentence says that. It also says a bunch of other things. So how can we rewrite this to make it clear, to make it clearly reflect the deal?
2 sentences.
2 sentences. Okay. Now, in my old days, I considered myself a prose stylist. And in my capacity as a prose stylist, I might say to you, 2 sentences, that's awfully choppy. To which my response as a contract drafter is, I don't care. It's clear. That's all I care about. It's not about style. If it's clear, that's that. So you can make it 2 sentences. How else could you do it? Doug?
A Romanet 1 after the first licensor, a Romanet 2 before a litigation report.
Well, Think about that. Isn't there a risk if we do it that way that the phrase requested by licensor might still apply to the first item in that series? I think there's enough of a risk that I'd want to tweak it a little bit further. Yeah.
So tabulate.
Yeah.
Licensee shall deliver to licensor.
Colon. With A and then B.
Right.
That works, right? Because that eliminates the possibility that requested by licensor, which is now clearly attached to the second item, from being read to apply to the first item. There's numerous ways to fix the problem. Identifying the problem is the hard part. And why is identifying the problem so hard? Because if you've written this, you're happy with it because it says what you mean. It also says some other things, but it's very difficult to see that. And this is where, the concept of editing one's own work comes in. And I try to impress on people how important it is, just like with anything else you write, if you have the time, write it, put it away, and then let some time elapse between the time you write it and the time you review it. And I also tell people you need to recognize the fact that these kinds of problems, 9 times out of 10, or an even higher percentage, are never going to be a real problem. Because if the parties to the business deal are otherwise getting along with each other, in many cases it almost doesn't even matter what the contract says. But one of our jobs is to protect our client against that 10% probability or possibility that there's going to be a dispute. And the worst case is there's a dispute and the parties each hand the contract to their litigators. And they say to the litigators, we're having a dispute over section 7.2D. Is the litigator only going to read section 7.2D? No, they're going to read the entire contract, and they're going to be looking for every provision that's kind of soft and squishy, every provision where they can make an argument that improves their client's case. And that is when your work as a contract drafter is going to be tested. It doesn't happen that often, but that's one of our main goals, is to prevent that from happening by being clear. All right, what's the problem with the second example?
It.
I'm sorry?
It.
It. Who is it? The it there could refer either to the contractor or the owner. We don't know who it is. Very common problem. You've got a pronoun without a clear antecedent. So we just need to be careful about that. If you're using a pronoun, you've got to be absolutely sure it's clear what the pronoun is referring back to. What's the problem with the third sentence? Anybody?
Well, I couldn't tell if the stock you were talking about meant the shares of stock or it's cattle.
Yeah, stock there, the word stock is ambiguous because of the context. Could mean capital stock or it could mean cows. Yes?
I'm concerned with the word exist. What happens if a lien is imposed after the signing of the contract? This says exist suggests that it's already in existence and that creating a new one might not violate.
I disagree with that because I think it's a covenant and it says rancher shall not permit it. My reading of that is if a lien comes into existence after the signing, there's a breach of that. I think if it was intended to just pick up liens that existed at the time of the signing, I think it would be instead a statement of fact that, like a representation, that there are no liens on the stock today.
I'd add or to be imposed on after exist.
To exist or be imposed on.
Some word like that.
Well, yeah, I mean, and you often see this kind of provision say, rancher shall not create, incur, permit to exist, or allowed to be imposed on.
Well, I don't like going into those long lists, but I think in this case, it's funny because I looked at stock and I thought of cows,
right.
But you're right. I mean, I can see the argument for corporation.
Because you saw rancher first.
Huh?
Because you saw rancher.
Yeah, absolutely, absolutely. Maybe maybe you're right. I'd be a little concerned about that exist.
Can I just say, as the client, I'd be asking the question about, now, am I paying for this?
Which is, by the way, why I would always tell the young lawyers who were working for me, if you're going to have a discussion with the other side about the difference between could and would, don't do that when the client is there, because they're not going to like that very much.
Okay.
So this kind of conversation, clearly better off not with the client sitting there and going, you know,
Yeah.
gee, you know, time's a wasting, or time's a costing. Okay, now we get to a principle of contract drafting. Yes, sir.
Some of us who do work in the transnational context,
Yeah.
I can see the problem of the ambiguity that you talk about. That if you are dealing with multicultural complex transactions, and then you get stuck on, there's an agreement on 80 to 90% of the deal, and you are stuck on a few things. Ambiguity is a saving type of false compromise that saves the deal. Preserve the situation for tomorrow.
False compromise.
Yeah.
I think so too.
It's a false compromise.
What is a false compromise?
A false compromise is an agreement that is not, it appears to be an agreement, but it is not an agreement. It preserves everybody's position. So that, you know, so that when the issue comes up, the issue may come up, or it may never come up. If it comes up in the future, bargaining power of the parties shift, and it can be resolved.
There's a recent case called United Rentals, where two big major law firms in New York did exactly that, where they had a disagreement, and at some point, it was pretty clear based on the description of the facts, at some point they just sort of said, let's just close, and it came back to bite them. Yeah.
I think there's some argument using vague terms in that situation. Because
Vague.
you're putting that off.
Absolutely.
But that's not an ambiguity.
No, absolutely. And I'm going to talk, and you know what, we're going to talk about vagueness in a
Yeah,
second.
I know this.
And absolutely, there are times when vagueness is fine, but I don't think it's fine to have a term that is clear, but which the parties don't really agree to, or have different interpretations, completely opposed interpretations of. I think that way you're asking for a lawsuit. Yeah.
Just to take issue, the United Rentals case was the Cerberus case, and it wasn't a question of just punting it off into ambiguity. I think the argument can be made that they were trying to be ultra precise, and what you ended up with was a provision a lot like the one that Jane showed, in which you gave with the left hand and then took away with the right hand.
Right.
That is this, and this, provided, however, this, which contradicts that. And you can make the argument that that is either an agreed ambiguity or it's an attempt to be over-precise, which somebody afterwards interprets as ambiguity.
Yeah.
So
I read the case a slightly different way. It seemed to me like it was the night before closing, and they just threw up their hands, and, you know. But we'll get to some of that in a minute or two. Okay. So one of the hallmarks of good writing, we all know, is, in fact, this is rule number 3 in Strunk and White, is you take out every word that doesn't need to be there. In contract drafting, that rule, or that principle, is extremely important because it has potentially, not doing it, has potentially a substantive impact. So here are 3 examples of sentences that have unnecessary words in them. What are the unnecessary words in this first sentence? Almost all of them.
All payments shall be made by wire transfer.
Wait, all payments, oh, you're saying that's what it should
That's how
say?
it be drafted.
Yes, okay. So let's start by the first. Here's one of my pet peeves. The parties hereto hereby agree that. Now, this introduces us to a concept which is tricky, which is the concept of legalese. We all know legalese is bad. And the herebys and the heretos usually can be omitted. But you have to be careful. You do not want your students to learn these lessons of what is a best practice of contract drafting, and then go to work and start telling the partners they're working for that their style of writing is wrong. You know, there has to be a certain accommodation to the real world. So the words hereto and hereby, you know, obviously you can change them to make them better, but I think it's a mistake to say never, ever, ever use it, right? Because they are used. So for example, where it says payments made hereunder, you could say payments made under this agreement. I don't have a problem with hereunder. You know, and I certainly wouldn't advocate that some first-year associate correct that language if it was written by the person they're working for. But this first phrase, the parties hereto hereby agree that, you'll see many sentences in contracts start that way, to which my response is, wait a second, this is an agreement, right? By definition, the parties are agreeing to every word in it. So why introduce one sentence by saying the parties agree that? Does that suggest that they're not agreeing to everything else? Now, I don't think anybody could ever make that argument, but unnecessary words, get rid of them. All right, but I don't think that's that substantive. But it's still, I find, very annoying. What's the problem? What's the unnecessary verbiage in the second example? It's a little trickier. At any time. As Jane pointed out when she was first talking about reps and warranties, reps and warranties, by the way, this is, reps and warranties are statements of fact that get made as of a point in time, or in some contracts, as of multiple points in time, right? They're made at the signing, and then they're made again at the closing. But they are not supposed to work so that they have to be true at all times. The words "at any time" here have the effect of converting those reps and warranties into covenants. A rep and warranty, if a rep and warranty says, you know, party A is not subject to any material litigation, and the purpose of that was to create a factual basis for the signing or the closing, this language means that if after the closing they're subjected to a material litigation, there's going to be a breach. That's not the way reps are supposed to work. So those words, at any time, may seem innocuous. They change the entire purpose of the provision into something else. Yeah, Mark?
If you strike "you shall be untrue at any time," what's the purpose of the balance that? Isn't it then necessarily a breach by you not being true if it's a rep and warranty?
I would write it to say it shall constitute a breach under this agreement if any representation by the obligor shall be untrue, you know, when made.
But why isn't that already the case without that sentence in there? It's truly a rep and warranty.
What? I'm sorry, I didn't.
Why is the breach of a rep, or why is the untruth of a rep and warranty not necessarily already a breach without that additional language in there saying it isn't?
That's a fair point. I mean, it would be a breach.
Once you strike untrue at any time, I'd argue you could strike the entire sentence.
Well, that's, you know what, that's a fair point too. I mean, in credit agreements, for example, there's a defined term, events of default. An event of default shall include, and then you have A, B, C, and D, and C is any rep is untrue when made. So, but I take your point.
In the UCC, there's such a thing as a warranty that explicitly extends to future performance. So the default rule would be that they don't, and there's that exception.
Right, and there you'd want to make it very clear that you were making a rep that did that. This, you know, when I wrote this, that certainly wasn't my intent, and most reps don't work that way. How about this last example?
So and significant. You don't need to say so comply, and you don't have to say significant if you've got material adverse effect. That's a defined
I think there's a bigger problem with this. I mean, the exception seems to be talking about a condition, and the first part is a covenant. I mean, you wouldn't have an exception to the covenant to comply with laws, rules, and regulations, but you might say that the failure to comply, if it's immaterial, is not a breach of condition.
Well, I hear what you're saying, but I think this. I mean, I think this works. It basically says, you know, lessee is promising. Another way to write this is lessee shall comply with all laws, rules, and regulations where, you know, where well, it's sort of the same thing, so, but okay, I mean, I'm not sure how to respond to that, because I think.
No, it's just a different approach.
Yeah,
I see what you're getting at.
but the gentleman in the back said there's two other things which don't belong there. The word "so," I agree, take that out. That's not substantive. There's also the word "significant."
Yes, which is redundant to material.
Well, it's redundant. Well, it's probably redundant to material. We don't know because we don't have the defined term material adverse effect, but we can assume that it has some concept of materiality in it. So here's the problem. Because material adverse effect is a defined term, we know that it's used at least one other place in the contract. What is the potential substantive effect of having this word significant appear here and not appear in front of material adverse effect where it's used elsewhere?
It certainly sounds as if significant is saying not every material adverse effect is covered by this.
Right.
It chopped something out that people didn't intend.
It's going to create, you've clearly created an argument
Absolutely.
that this material adverse effect here, or the standard here, is higher than it is where material adverse effect is used elsewhere. But how does a mistake like this creep in? It's very common, right? Because in the first draft of this agreement, maybe the term material adverse effect hadn't been defined. Maybe the language just said failure to so comply would not have a significant effect on the business of the lessee. And then, because in the second draft, other similar concepts were introduced, someone said, well, let's create a defined term, we'll create material adverse effect, and they stuck that in here, but forgot to cross out the word significant. Now, if you could show the judge that, if you were trying to convince the judge that the word significant really didn't belong here, that might be nice, but you're probably not going to be able to. All right, now we get to vagueness, which I think a few people have already touched on. Ambiguity, I think, is always bad. You should never have a provision which two people can read to mean completely different things. Vagueness is different, though. Why? Because there's an element of vagueness in everything we write. It's just inevitable. You can't define things down to the nth degree. And in fact, there's many, going back to the earlier discussion that we had about the client saying, come on, let's just get this done. There are many situations where we have to sacrifice precision just in order to get the deal done, in order to achieve the client's objectives. And here's an example of that. Doug, I'm going to ask you to volunteer. Thank you. Okay. So Doug represents the company that's here called the issuer. And this, I'm representing an insurance company who's lending Doug's client $100 million by purchasing 5-year notes. So I do a first draft of the note purchase agreement, and here's a covenant in the agreement, a promise by Doug's client, which is a big, complex, multinational company with subsidiaries in 23 different countries. So here's a covenant I'm asking Doug's client to agree to, and it's effectively they've got to be in compliance with this covenant at every moment for the next 5 years, or they're going to be in default, the debt could be accelerated, all kinds of bad things would happen. So we're now getting on the phone to talk about my first draft. What do you think, Doug?
Well, I don't think my client can live with this covenant.
Are you telling me your client's planning to violate the law?
I think it's quite possible that there is some minor law in some jurisdiction that's being violated at this very minute. Yes.
Oh my God! I'm not sure my client really wants to do business with your client.
If one of the drivers delivering a package gets a speeding ticket,
you
think this transaction
I can't believe that. That's my example.
You
stole my example. Okay. Yes.
Should collapse because of the speeding ticket?
Okay, Doug. Here's what I'll do. I'll revise this covenant to say, except as set forth on Schedule D, issuers shall not and shall not permit its subsidiaries to, and then you can list on the schedule all the laws that
And
your
I'm
client...
supposed to go through the laws and rules and regulations of 50 states and every municipality they're located in and every country, and figure out every possible minor infraction that might be committed between now and the closing?
Okay. Besides
Not
which,
realistic. I don't have enough lawyers in my law firm to do that.
Besides which, not a good idea to put down in writing, here are the laws that we plan to violate. Yes, okay. So, now Doug's approach could go exactly the opposite direction. He could say, this is so broad, just put a big X to it. At which point I'd say, well, wait a second. Clearly, if somebody gets a speeding ticket, I shouldn't be able to accelerate the loans. But if you're out there doing really, really bad things, I should have a remedy. All right. So how do we cut this baby? How do we create a covenant that protects my client against his client doing really bad things and protects his client from a footfall which could bring the whole debt structure down for something that really doesn't matter?
Well, I think we could talk about material violation.
There we go. We talk about materiality, and in fact, where we often end up is something like this. It's funny, you know, I did deals where I often find myself on the opposite side of the same people from deal to deal. And, you know, he'd do a first draft, and we'd get on the phone, and I'd say, okay, Chuck. I'd say, you know what I'm going to say, and I know what you're going to say, and then you know what I'm going to say, and we both know where we're going to end up, so let's just agree to that.
But it never works out the way you expect it. Exactly. I've been there 100 times, and it never quite works out how you anticipate.
That's right. So this is where it's likely to end up. We've now limited the effect of this covenant to violations of law that could reasonably be expected to have a material adverse effect on the financial condition of the issuer and its subsidiaries taken as a whole. That protects my client against his client doing really bad things, and it protects his client against being in default for really small things. But it's not crystal clear. Material adverse effect is a notoriously slippery concept. And there's litigation on it, and you know, there hasn't been enough decided cases on it to really know what that means at the margins.
But when you're talking to your clients, and you were still practicing law, and they wanted some guidance from you about how bad it had to be material adverse effect, what would you say?
Oh, I'm not going there. I'm just not, because it always depends on the context. And you know the cases. There are cases which say, you know, completely different things depending on the context. So I don't even want to get into that discussion. Yeah.
Well, I was thinking that in the earlier example, you defined material adverse effect because it was capitalized. We didn't get to that.
Well,
and that's a real question, whether you want to go with a vague term that you're going to argue about afterwards, or try to define something that's almost impossible.
it's almost impossible. And in fact, there's another recent case, a busted LBO, the Sally Mae case, where the lawyers actually tried to craft a material adverse change clause that was precise with respect to certain litigation that Congress was considering, saying that litigation, if it's passed, will not be a material adverse change. But then, of course, they passed some litigation which was just a little bit different.
If I could just add one other point, I don't know if it's a vagueness question, but reasonably could reasonably be expected, protects the issuer, but not necessarily the other guy, because what if they violate the law and it really brings down the company, but it doesn't violate this provision because it couldn't reasonably have been expected to do that, but it does do it.
Well, that's another, there's really two elements here
issue
that could be easily be litigated. And my point here is that in order to get this deal done, and in order to protect both clients' interests, we've been forced to use terms that are ripe for litigation if the parties start fighting with each other. Yeah.
I can see this within the context of boundary rationality. If you use reasonably expected, what you are suggesting that if you look at current business methods and business standards and current expectations among people who are in this line of business, certain things are reasonably expected. If something unusual happens, then it falls outside this, this provision.
I'm not sure I agree with that. I think if something unusual happened, it's not a question of whether the thing that happened was reasonably be expected, but whether the thing that happened whether a reasonable person would look at that and say, well, I expect that is going to or could have a material adverse effect on the company. But it's just another example of how words like this, phrases like this, inherently vague phrases, just can lead to different interpretations and potentially disputes. But the takeaway is sometimes we're just forced to do it. And now from the client's perspective, you know, if the client, Doug, if we agreed to this language and the client called you up 2 years after the deal closed and said, we just got a speeding ticket like in our Colombian subsidiary, have we violated this covenant?
No.
No. I love the way you answered that. You know, when you ask first-year associates that, they are almost never willing to say no. No, you haven't. Okay, a week later, the client calls you and says, Doug, something really peculiar just happened. The FBI and the SEC came to visit us, unannounced. They took the CEO and CFO away in handcuffs. They've impounded all our books and records, and they're charging us with 73 violations of the securities laws, which, by the way, we committed.
Yes.
Yes. But guess what?
How does he know that? How does he know that without looking at the...
Okay, you're right, but
Well, I know that if they've taken away all the if they've arrested all the senior management and pounded all the books and records of the company, that's going to have a material.
All right, well, I didn't hear him pound the books and records.
yeah, okay, but let's just say it's pretty clear that that's a yes. My point here is those are never the questions you're actually asked. You're asked the questions in the great middle area where the client's going to ask you and you're going to say something like, there are arguments both ways, or it's a gray area, and that's when the client starts saying to themselves, we're paying you guys hundreds of dollars an hour, and you cannot write a sentence that's clear. But there was no better way to do this. Right? I mean, how
You're asking me?
well, no, I know I'm not asking you. You're the client. You don't know the answer.
But what I would say, as both the lawyer and the client, is this is a backup mechanism. It's only the lawyers who think that they can have this fantasy that they can draft things clearly in view of the great contingencies of the world. And what this is a backup mechanism. If you can't come to an amicable agreement, you're going to spend millions of dollars with wild gotcha and scandal litigating yourself to death.
Right.
Yeah.
That's it.
Charles, one way of handling it, of course, is definitional, and I use contract provisions for either material or material adverse effect for a dollar value.
You can put dollar. Anytime you can do that, you're better off. But
they don't usually accept it, but
see, my argument from my perspective would be dollars don't always capture it. You know, you can violate the law in a way that destroys your business, right?
You could be a financial firm and indicted on it for a crime that has a $1,000 fine,
right,
and you're out of business.
Yeah, there can be all kinds of non-economic effects. So I would say, you know, that just doesn't do it for me. I mean, it's a situation where it's really hard to do it precisely. It's really hard.
Ask the question whether the recent kerfluffle with Goldman Sachs violates that provision.
That's a good question.
Yeah.
Someday we'll find out. All right, you know what? We're running short on time. Let me just, I'm not going to get to everything, but I want to get to a few examples of vagueness that are unacceptable, right? We've talked about how sometimes vagueness we just have to accept in order to get things done. There's a level of vagueness that's so bad that a provision doesn't mean anything, doesn't have any meaning. And here are 3 examples of that. First example. Seller shall maintain adequate insurance on the subject assets. How do we determine what's adequate? It's not clear.
And that's the type of thing that you could make perfectly clear.
Of course. Well, in a leveraged lease or in a project finance, you have insurance provisions that go on for 10 pages, right? Or if you want to shorthand it, you could say, seller shall maintain insurance on the subject assets that is, comparable, in amounts and with terms that are customary in the industry. Now, obviously, there's room on the margins to argue what that means, but there's enough there for a trier of fact to actually determine it. Here, the way it's written, it's just totally open-ended. Next one. Company will not be required to close if there's been a material adverse change. Material adverse change to what? It's not a defined term, so it doesn't really mean anything. And last, at the request of any investor, a satisfactory legal opinion shall be delivered. I tell my students, when you're talking about performance obligations under a contract, you need to be thinking about who, what, when, and where. Not usually why, sometimes why. Who is supposed to deliver it? The subject of the sentence is missing. Who is entitled to delivery? The object of the sentence is missing. Who determines what's satisfactory? When is it delivered? I mean, all this stuff is missing. So this is just so vague that it is unenforceable, and that's never a good thing. I just want to mention my last category of areas of bad drafting, and that is where terms that should be consistent are inconsistent. And to illustrate that, I've got two sentences here from a residential real estate lease. The tenant wakes up one morning and she looks out her window and she sees electrical workers stringing huge power lines across the middle of her backyard. So she calls up the landlord to tell the landlord says, oh, I know, I granted an easement to the power company to do that. So she pulls out her lease and she says, wait, look, you said, this is a rep, by the way, the first provision is a rep, it's a statement of fact. You said that there were no easements. And the landlord says, well, when we signed the lease, there weren't any easements. I granted that easement a week ago. So she flips, she thinks to herself, I remember seeing that. I remember seeing that rep and she didn't know it was a rep. I remember seeing that provision and noticing I didn't have any protection going forward on that subject. And I remember asking my lawyer to fix that for me. So she flips through the lease and she finds the second provision, which she doesn't know this, but we do. It's a covenant. She says to the landlord, look, you promised. What does the landlord say? The landlord says, I don't see easement in that sentence. So at this point, the tenant covers the phone up, the speaker of the phone, she curses out her lawyer, she gets back on the phone and says, well, okay, but I think the word encumbrance is extremely broad and would include easements. And what does the landlord say? Well, obviously, we didn't intend it to include easements, because if we had, why did we specifically refer to easements in the first provision? The landlord probably wins this one. Now, was that intentional, that those two provisions are worded differently? No, it was a mistake. How do I know this? Because I made up this story. So I'll tell you how this came to me. The tenant's lawyer, in response to her request, was drafting a rider, creating this covenant one night, and as he's basically copying the words from the rep, right after he writes the word encumbrance, his phone rings. And his wife's on the phone, and she's extremely upset because their 15-year-old son, Timmy, just came home with a ring through his nose like this. This happened to me. I wasn't drafting a rider, but it did happen to me. It's a very upsetting phone call. And so he gets off the phone, and he just makes a mistake. All right? Inconsistency. He should have probably created a defined term. All right, I apologize. I didn't really get a chance to get to all of my materials, and we're already past time, but we were supposed to have a Q&A, but there was plenty. So I think we're done, but if anyone wants to talk further, we're going to be here.